have a new case from a federal court of appeals that reminds us that while sexual harassment is what we really talk about the most in the harassment realm, that harassment on the basis of other forms of protected classes is also illegal. This particular case came out okay for the employer, but it is a good reminder that a lot of the same and similar rules apply. So first, just a minute about the case. The plaintiff was a former law enforcement officer, suffered a serious hand injury on her job, ended up ultimately being transferred to a desk kind of job that fit her capabilities in light of the long-term injury that was caused by that. She alleged that first a couple of co-employees harassed her, made fun of her workspace accommodations, adjusted her chair in ways that weren't comfortable for her. The employer transferred those two away. Somebody else came in. She complained that that person also harassed her with unkind comments. So the court said under the Americans with Disabilities Act, yes, it is illegal to harass somebody based on her disability. But in this case, the plaintiff's evidence did not rise to the level of severe and pervasive, which will sound, of course, familiar from sexual harassment cases. And, for example, in the case of the second colleague that she complained about, after the other two were transferred, there were 3 allegedly insensitive comments over a period of time. That doesn't rise to the level. We'd expect a similar result in a sexual harassment case, I think. Sounds like the first 2 may have been a bit more conduct. The court acknowledged it was unkind and negative, but still did not rise to the level of actionable harassment. And the fact that the employer transferred them, that was an emphatic step by the employer that the court found was an appropriate measure to address it. We read these things as we do sexual harassment cases and think, this is something we would want to address in our workspace for sure. And one thing I've said in the sexual harassment context is the standard for these going to become a little easier to meet for a plaintiff. There are states where the severe and pervasive standard has been changed by statute. Not many, but that's a discussion that's going on. So this all plays into that. I think the important thing to realize now, and something to check yourself on, is that it's not just sexual harassment on the basis of disability, age, race, national origin, any status that is protected by law is also illegal. You want to make sure your policy is addressing that as well. A lot of employers have an EEO policy that sort of covers everything. They'll have a harassment policy that tends to be very sexual harassment focused. And that's okay to an extent, but we just want to make sure if you got a case like this, we can hold up a policy that makes it clear that such conduct towards somebody with a disability is unacceptable.